And we are back with our second session for the plenary 2023-60, the Law Intensive School. And I will say good morning to you all, and thank you very much to our next session is actually going to be a joint session. We have two guest speakers joining us this morning, and I'd like to welcome both Rebecca McMahon, barrister, and Mr. Russell Kavanagh from Legal Aid, who are both joining us this morning. Can I just check that? Where is Rebecca? Oh, good morning, Rebecca. I had to scroll along a little bit. Good morning. Just wanted to check that you're both here. So by way of introduction, a very warm welcome to you both. Rebecca was, before she joined the bar, she was the principal lawyer of her own private law firm for 10 years, appearing for clients in criminal law matters in the local, district and Supreme Courts, as well as appearing in the Mental Health Review Tribunal, Guardianship Tribunal and inquiries. From 2010 to 2011, she was a managing lawyer of the Redfern office of the Aboriginal Legal Service, and she has been a criminal defence lawyer at the New South Wales Legal Aid Commission from 2007 and 2010, and a lawyer of the New South Wales Office of the DPP from 2003 to 2007. So she's also currently adjunct at the Faculty of Law at UNSW, and she's been lecturing there since 2010. She's also lectured criminal law subjects with us and the University of Sydney and UTS. So she is no stranger to teaching and learning. She is with us today because she is the co-chair and one of the founding members of the Bugmy Bar Book Project. And we're very excited to welcome her and to hear more about the Bugmy Bar Book Project, which aims to assist legal practitioners and the courts to understand the impact of experiences of disadvantage in the context of sentencing. She was the 2021 recipient of the Terry Keneally Memorial Award, which recognises dedication to profession, excellence as a criminal lawyer, commitment to clients and concern for social justice issues. And we congratulate her on that. Russell is also a sessional lecturer with us. We love having wonderful people join us who have experience in practice, and I gave a brief introduction on him earlier because he had a great question for Justice Musgrave if you're in the earlier session just now with us. He is an Aboriginal man from the Dorog clan of Western Sydney, but he now lives in Port Macquarie, as I understand. We've had a few chats up in Port. And after serving, he served with the Australian Army as a combat engineer, but he spends most of his time these days with Legal Aid as an Aboriginal legal access officer, assisting clients in 3 divisions of crime, civil law and family law. He is a very busy man. He has experience working in community, and he's been accredited as a mediator working through the Australian Dispute Centre program, and he has been invited to the New South Wales Parliament to be an advisor and a presenter for the Law and Justice Foundation to discuss technology and the law into the future, which trips me off as to his deep interest in the future of law and technology. In his current role, he works in the private lawyer quality standards unit, auditing and assessing solicitors and barristers' work under the Legal Aid's quality standards guidelines, which means that we should all continue to have higher standards moving forward. I'd like to warmly welcome both of them to this session and open it up to them to discuss the Bugmy Bar book project. Thank you to both of you for taking the time out on a Saturday.
Thanks, Lisa.
And what a lovely, warm introduction. Really appreciative of that, and lovely to be presenting with Russell as well. But before we commence, I just want to acknowledge that I'm on Gadigal land here in Lewisham in Sydney, and want to pay my respects to elders past and present, and my respects to all of the First Nations people on this Zoom and who will listen to the recording. So this morning, I've just put in the chat a summary to the case of Bugmy, which of course is central to what we'll be talking about today, or certainly what led to the Bugmy Bar Book project. But just as a bit of an outline, what we want to do today is, first of all, I'm going to be talking about the Bugmy Bar Book and what it is. I know from talking to Mark earlier in, where are we? Yes, earlier in the week, that you have had some exposure to the Bugmy Bar Book project, but I want to explain it a bit for you. And just talk a little bit about how it might be used in practice, particularly in sentencing. Russell's then going to talk about how it can be used in civil law and other proceedings. And then I'm going to finish off on talking about a case example for you as well. But before I hand over to Russell, who is firstly just going to be talking about whatever he pleases, but it might include why it's important for practitioners and judges to have a better understanding of First Nations experiences in legal proceedings. I just want to invite everyone, and now this is very unusual for a lecturer to do this, but I want everyone to feel free to get their phone out and to Google the Bugmy Bar Book and to be flicking through it and having a bit of a snoop around. I was going to share my screen, but I don't want to waste time doing that. So please.
You can if you want. If you want to, Rebecca, I've given you access.
Oh, that's terrific. Thank you. But I think it might be better if people can actually just use it and have, as we're going along. And thanks for doing that, Lisa. And another thing you can do at some point in this session is subscribe to the Bugmy Bar Book, because we are about to have quite a number of new publications come out. And if you subscribe, they'll be in your inbox. So feel free to do that in this session as well. But Russell, please talk about why there needs to be a better understanding of First Nations experiences in the legal system from your perspective.
Hi, morning everybody, and hello, hi elders. I'd like to pay more respects to you this morning. I think the most important thing about the Bugmy Bar Book is that it's actually opened up a lot of people's understanding and thinking about how to work with and to deal with Aboriginal people, and how they are seeing the world. A lot of people in Aboriginal communities are suffering basically on a daily basis. And the reason being is there's so much grief in the community because of, yes, the colonialisation that happened and the impact of that. But what's happened is we bring that forward to this century. It hasn't really changed. I personally remember the times when my grandmother would say, "Quick, get inside! Here comes the cars. They're going to they'll take you away." This hasn't changed. It's still got that connotation that still to this day is in community. And what it has met with is an aggressive nature towards authority, where really and truly, if there was an opportunity for people to feel that the authority isn't there to hurt them, but there to work with them and to be able to. But the problem is as we know, not all authorities actually inviting. There's also been a situation there that people feel that they can't trust people in authority, such as the police, docs, or DCJ as they call it now, and because this is evident from working as a field officer I did for quite a few years, working with solicitors, working across the impacts of crime, the impact that has in the civil platforms and into family law. And I think that's the issues that we sort of see here, that culture plays a major, major part, and the importance of culture in Aboriginal community is something that's really, some people just don't realise that how important that is to the community and how that determines who they are. How they react to certain situations. Sorry Business is a perfect example of that, where people in community find a lot of difficulties dealing with mainstream because of those sorts of things that mainstream's community doesn't understand the difficulties of dealing with the values and sorry business that happens in community. So it's a very it's a situation for an Aboriginal person is a balancing act between dealing with what mainstream does, says, and how to also integrate and work within your own community and your own culture. Not all Aboriginal people are the same. I know when the word Aboriginal it's a blanket word, but people from Wiradjuri, Gamilaroi, Biripi, all over the country, we all have different values. We all have been raised in different ways. We all are Aboriginal people, but the thing is but what it is that our values will also stem back to our communities and to where we come from. And that's really, really important, that not all Aboriginal people are the same, as I mentioned. And that is one of the reasons why in this particular talk today, that the exposure that we have to violence is on a daily basis. It's not just every now and again, it's on a daily basis. It's also the impact of childbirth and the issues around childbirth and the use of substance abuse has actually created a lot of issues that we actually are suffering with through our children, and also around the difficulties of children trying to understand the importance of going to school, and also how that's going to find us in the future, that we're going to have difficulties trying to understand, to try and get people, Aboriginal people and Aboriginal children to try and engage with the mainstream system. But it's really difficult because we're fighting constantly against a system that's actually has always pushed us down, always pushed us below the level of the garbage tip. And every time you want to lift your head above, it's going to get smacked down again. And that's probably one of the major issues that is always going to be there until such times as we see a progression in our society, and our society values of accepting of people are different, and that they have other ways of looking at things from a different area. Over to you, Beck.
Thank you, Russell. It's always such a privilege to listen to you and your perspectives. And where do you go from after hearing your perspectives? But thank you. Look, I just wanted to say, just kind of bringing back to the Bugmy Bar book, and I will talk about the decision in Bugmy in a second, briefly, but I just wanted to emphasize, and this is me, a non-First Nations person, saying that we do have chapters, and you will see if you've looked on your phone or device, that are specific to First Nations people, impacts of people who are members of the stolen generations and their families, and also the impacts of cultural dispossession. And the purpose of, and sorry business and so on, and the purpose of those specific chapters really are to assist with cultural competence and understanding of issues that Russell has been talking about. And I just wanted to say that those particular chapters have been developed by First Nations people, and they have been reviewed by the First Nations members of our committee and independent panel. And that cultural competence, self-determination content is a critical value and something that we recognise in terms of the integrity of that research and presentation. So I just wanted to tie that in with what Russell's saying as well. But I might just move now just to spend a little bit of time talking about the springboard of the Bugmy Bar Book project, and that was the Bugmy decision. And of course, that involved Mr. William Bugmy. And this decision actually is coming up to a 10-year anniversary in October this year, having been handed down in 2013. But he was a Barkindji man who had some charges which arose out of some assaults that occurred in custody when he was in Broken Hill. And I won't go into as much detail as I could, but basically, at sentence, he was 29 years old. He was experiencing auditory hallucinations and brain damage. He had a background of profound disadvantage and issues of trauma, having left Year 7 also in terms of his educational disadvantage in Year 7 with a range of difficulties. Now, I could talk through the appeal process, but one of the key issues is that Justice Yehia, who is now Justice Yehia, was then a public defender. Part of her argument was asking the court to take into account the systemic disadvantage and deprivation caused by colonisation, and asking the court also to take into account overrepresentation of Aboriginal people in custody. Now, that particular argument didn't succeed in the sense that individualised justice was held to be the way in which offenders should be sentenced. However, there were some very important principles that came from that decision, and they included first of all this principle that the High Court held that the same sentencing principles apply irrespective of the identity of a particular offender or his membership of an ethnic group. Now, that obviously came off the back of not holding the individual experiences of Aboriginal people, the collective experience rather of Aboriginal people. But what was more important and fundamental that we in terms of recognising the impact of disadvantage is that the court held that the effects upon offender of profound deprivation do not diminish over time and should be given full weight when sentencing an offender. So that's been really important for the development of our work, because what that says is every single time someone is sentenced, whether it be their first, second or 50th matter in their criminal history, the court must, not as a discretion, but must take into account all of the things that they have experienced in the past that may have impacted their development behaviour, and in some cases can be clearly linked to their offending behaviour. Now, the case also held, and so the Bugmy Bar Book, in recognising that, has sought to think about, at least at this stage, some of the experiences that regularly come before the court for people, to pull from major reports, leading academics and so forth, and collate that material in an accessible way so that practitioners can draw upon that research and show the court the likely impacts that are likely to flow from a particular experience of disadvantage. For example, parental incarceration. For example, someone's diagnosis of FASD and how that might affect their development, behaviour, mental health and other outcomes, so that the court can have a proper and deeper understanding as to what these experiences mean for an individual. So I was going to spend a bit of time talking about how the Bugmy Bar Book developed, but I'm also very conscious of time. And what I might do before handing back to Russell is just to explain, and please feel free to look through the chapters, how, if you have a chapter, how it could be used in a particular preparation for sentencing and then used in sentencing itself. So you might take, for example, the parental incarceration chapter, okay? So the first thing I would say about that is, as a practitioner, is that you could read that particular chapter and use it for education, okay? To use it to understand how your client may have been affected by the fact that mum or dad spent time in prison, because it can be profound, okay? The research does show that that experience is likely to have impacts upon mental health, impacts upon bullying, stigma, and so forth. So you can educate yourself about that when approaching a client. That will then inform how you might take instructions from someone, because when you appear for someone on sentence, you will collect evidence for them. So, or you might call them in the witness box. So you're better informed about the likely impacts of that experience for your client and can ask them questions so as to adduce a richer body of evidence from them about how that experience might have affected them. The next thing that you can do with that chapter is to put it in a sentencing bundle. So you will have called evidence from your client about that experience. You may have, for example, the custody records of that parent to establish that this experience took place. You might also have information from aunties and uncles who might have said during that time, this is how this experience appeared to affect the person who's before the court. So that's the rich body of evidence that you can adduce, but then you marry that with by tendering the chapter itself, and then it gives strength to the particular evidence for the person who's being sentenced. And then you can submit to the court that these are the likely outcomes based on, you know, the leading, strong, you know, best evidence that we have on this particular topic. And you can invite the court and tell them that it will assist them to make safe findings about the impacts upon that person. The other way that this chapter can be used in this hypothetical sentencing situation is by giving it to an expert, because as you will all be aware, very commonly psychological or psychiatric reports are commissioned for people who are before the courts, and often you need that if you're going to establish that someone may be experiencing a major mental illness. But what I do in my practice, and many others are starting to do now, is when you brief the expert is to provide relevant chapters to that expert. And particularly if you have a non-First Nation psychologist or psychiatrist, you might be including those chapters that I talked about before that are particular to First Nations people, and including the report that Mark has referred to here in the chat, which is strength-based evidence about the power of culture as it relates to wellbeing and rehabilitation, and asking that expert to specifically comment about the applicability of that research to the individual that they are assessing. And that does, I can tell you, absolutely does lead to better expert reports, richer, more culturally competent expert reports that ultimately assist your client in sentencing. Now, I'm going to stop there for a minute because I feel like I should hand back to Russell. I'm watching the time as well, about how the Bugmy Bar book has and could be used in civil cases. And then I'd like to come back and give you some more examples in the context of criminal law.
Okay. Thanks, Beck. That's really good. Just following on from where you were talking there about people with mental health issues. In the civil sector, some people mightn't realise that actually in that civil sector, and what civil actually means, civil is everything that's basically, which isn't criminal and isn't family, and that's civil. So you can imagine everything else that's left is, you think, well, what else is there left? There is a lot of issues out there in the civil environment. Schooling is an example of this. Schools, and it's one of the issues that we see a lot in the civil sector, is Aboriginal children who have been exposed to domestic and family violence in their development. Down the track, it manifests itself into trauma, and it becomes intergenerational trauma. And this creates a lot of issues that people don't understand. It actually can impair and stop the ability of the frontal lobe of the brain functioning effectively. And also, what this also causes is the ability to be able to learn easy enough, It increases frustration, and you get a lot of people, a lot of young people in this particular area where Bugmy really applies, is that it becomes there becomes destructive behavior towards the person themselves. They lose the ability to have emotional control. The learning difficulties, actually all they do is actually gather the momentum as people go into teenage years, then into adulthood. And this also causes depression and poor mental health status. The ability to feel good about yourself becomes depleted to the point where they just basically don't care anymore. So one of the situations in civil particular area is that a lot of Aboriginal people become homeless because of their inability to be employed, to get employment. Also, because of the frustration within themselves, the ability to be able to look after some of the houses that they live in. And because of we get overcrowding in some of those houses, we get what they call 90-day removals that are put forward by that are put out there for them to be out of the house in 90 days. So you can imagine how a mum with 4 or 5 children, plus also possibly nephews and nieces that they're all looking after, their ability, and they're trying to fight with themselves, plus also look after children. The cumulative effect of this creates an inability to regulate their emotions. So consequently, there would seem to be a lot of anger happening in the house. And this then creates the platform for for instance, real estate agents to come in and say, well, we're going to put a 90 days down for you to be removed from the house. You've got to get out of the house. Where do I go? What do I do? Go to my cousin's house and live there? So from a civil perspective, a lot of the times, this goes to tribunal. And at the tribunal, Bugmy actually is becoming really, really an effective tool to presenting to the tribunal member what the person in front of them and the issues that they're facing and why those issues are causing the problems for them to be able to get employment, for them to be able to look after the children that they're looking after. It's something in community that we do. I remember myself sitting being a house with my grandmother where there'd be all these other children there, and I didn't know who they were. And I was asked my grandmother, "Who are these?" "Oh, they're your cousins." And it's like, but what happened was that she used to look after us all, and it was an acceptance in community that we used to go to Nan's to get looked after. And that was one of the things that was real important, that we had somewhere. But now, in our society now, if you can't provide adequate a bedroom and a bed for a child, you then come under the microscope of DCJ, because you're not providing adequate housing and a roof over the head for children. So what happens in the civil context goes over into the family context as well. So Bugmy actually therefore can actually be used as a strong platform to explaining why to the tribunal member why it's imperative that this woman or this family should be able to stay in the house, because the knock-on effect into other areas of the law is profound, insofar as that you have the chance then of your children being removed or becoming homeless, or if you've got mental health problems, exacerbate your mental health problems to another stage where there's a chance that you may commit a crime purely for survival purposes. You may steal, you may shoplift, and because you're emotionally upset, people quite often, as some of you may know, that people will jump in a car and drive it really crazily because of their emotional state, just to escape, to get away. And these are some of the areas that we find that in the civil area, that Bugmy is actually really showing a a hard foundation to springboard off into explaining the circumstances and situations why these particular people are becoming homeless, their children are being removed, they've got anxiety issues, mental health problems that have been exacerbated by society altogether, coupled with the fact that you've got people around you who could possibly doing sorry business, and they're looking for a place to live while that's happening. The other area that has quite as has been ignored for quite some time, where Bugmy is actually showing some really strong efforts and effects, is actually in the area of coronial hearings. We have in community, we have a lot of people that pass due to suicide, mental health, substance abuse, pass away because of sicknesses such as diabetes, kidney failure. And one of the problems is the coronial area is right now it's very adversarial. And to Aboriginal people, straight away, this is really, really hard a hard time for them, because they're trying to deal with the fact they've actually had somebody who has passed away in their family, and they may have passed away while in custody. I suppose, don't need to explain to you in regards to David Dungay is a perfect example of that, and what happened to him, how he died in custody. When the coronial hearing happened, it was actually a person sitting up there who didn't take any notice of the family's grief and how much the family were grieving. What is coming about is the fact Bugmy is actually something that we can start to impress on the coroners and say and use those particular areas that I just mentioned, saying that the upbringing of some of these people is their cognitive function is one of the areas that they're not understanding this process. You're not making them inclusive in the process of coming to a understanding of why somebody passed away, what was the reasoning. So you can imagine that over time, the frustration of dealing with of family members passing away on a regular basis, whether it be in custody or whether it be in a situation where they're actually in jail, or their home life has become so bad that they've committed suicide. In the world right now, young Aboriginal males have the highest suicide rate in the world. And that age group from 14 to 25 is seeing some of the highest statistics in regards to that. And this is why Bugmy plays such an important role in identifying to society, this is where they've come from. This is what's happened to them. This is why they're heading down that path. We need to do something better and come at it from a different angle. We're failing on so many angles, and this is why Bugmy, as I say, it's such an impressive piece of work, is something that we actually need to look forward to in our repertoire. Have it under your arm when you're going into court or when you're going into tribunal. It's something that you need to actually really understand and grasp the whole concept of why it is so important that these particular issues and the long-term exposure to violence creates a situation where the inability to be able to regulate your emotion, and in some instances you've got young people in very young age that they don't know it, but they're walking around with PTSD.
Yeah.
They've got PTSD all the time. Yes.
So, Russell, it's Lisa. You've spoken beautifully and articulated it in such a way about the depth and the longitudinal, challenge of the grief and pain and the magnitude of the challenge that is facing Aboriginal people at scale. There's actually a question from a student in the chat box that I'd really warmly like to invite Claire, if she's listening, to be able to actually ask you about it, or I'm happy to ask it on her behalf, about about support, because it kind of feeds into some of the narrative that you've been talking about. Just before, because we might be, about to change tack onto something else, and I want to acknowledge, everything that you've just said, and to kind of, to bring it together in terms of talking about the challenges and the grief and the pain and the suffering that's going on and the magnitude of the problem, by talking about, well, what support, what services are able to continue to support people after a sentencing decision has considered Bugmy, and what does ongoing support look like? What do you know about that in terms of being able to address that?
Okay, some of the issues around support. A lot of the supports in society and community, well, actually not in community, in mainstream society, don't have the cultural understanding. And that is one of the reasons that we find that a lot of these issues go by the wayside. An example of that, there was actually a service provider here on the mid-north coast for 8 years received money from a government department to provide assistance and support into, for instance, Bowraville. For 8 years that they received, and it was turned out to be several millions of dollars. And one of the reasons that they said that when they were challenged about why they didn't provide the support and service to that community is because they said, oh, we haven't got an Aboriginal person working for us. And it's like, well, wait a minute, what do you mean you haven't got a normal non-Aboriginal person could still provide support, but we're not going in there. We're not going to provide support because we haven't got an Aboriginal person, was their concrete answer, which is one of the reasons why people think that you hear funding going into an Aboriginal community. It doesn't necessarily make it down to the grassroots. That is one of the problems that we see time and time again, is that when we challenge in the civil context in tribunal, they say, well, why didn't they get help? Because a lot of the support services out there are not provided to Aboriginal support services, and or the support services that are out there don't employ Aboriginal people. And one of the reasons being that is that that the cognitive issues of a lot of Aboriginal people makes it very difficult for them. Plus, also, if you're an Aboriginal person working in a support service, the emotional drain on that person, because they become the contact person for everybody in community. You're the person. And what happens? They become emotionally drained and become so upset in their own world that they have to take time off because they become emotionally drained because of the issues. This isn't something that's small. This is something that's a massive problem, particularly when you hear people that you might have spoken to the day before and they've died that night over something that they never made it to hospital, or nothing, or the services didn't go there. So they weren't getting the services coming up to help them deal with their issues, whether it be mental health or whether it be physical problems. These are some of the issues that why support services aren't available.
Thank you so much for that, Russell. I want to acknowledge Jen Hartley, who's raised her hand, and a very good morning to you, Jen.
Thanks, Lisa, and thank you, Russ and Rebecca, and welcome and good morning to our elders. I apologise for the croaky voice. I'm not very well, but I just have a question around how the Bugmy Bar book can be used in the correction space. So I was only speaking to a good friend of mine last week, and her sister's actually in corrections just up here on the mid-north coast for a very petty minor offence for shoplifting. She has a young child. Her mum is raising her child, and she's a First Nations woman. And she has promised her child that she would call her morning and night. So she's the first person she speaks to in the morning and the last person she speaks to when she goes to bed. However, in corrections, she's on an unemployment rate of $16 per week, and the cost of making a phone call per day or per call is $3. Now, you can understand, I guess, the money she's receiving on that unemployment rate is a lot less than what she can actually afford to make those phone calls. So I'm just curious, is this a space that the Bugmy Bar Book is considering or looking into moving forward?
So that's heartbreaking, absolutely heartbreaking stuff. Jen, are you talking about prisoner support? Is that the issue that you're?
Yeah.
Let me say this: the Bugmy Bar Book is responsive to needs. You've just told me something, and I will feed that back to our committee about what on earth can we do about things like this too. There's so many issues that can be covered and that can be responded to. For example, the chapter about sorry business, because obviously this issue coming up time and time again with, people needing to do what they need to do culturally and it affecting them with breaches of bail and things like that. So that chapter was in a direct response to that need, and it's now being used in that sort of space, and it is effective. So what you're saying to me is something that I will also take back to our First Nations committee members, because we're talking about issues like cultural connection, right? And the importance of cultural connection to wellbeing. And I think, I could say Vanessa and Paul's report that Mark has put in the chat is relevant to that, but perhaps there's something more targeted that might be needed too. So what you've said, I have taken on board, and I think I'll talk to our committee about that.
Thanks, Beck. Yeah, no, I was just curious because we've referenced the Power of Culture and Wellbeing report. Well, we know being connected to community and family is so significant for all First Nations community. How is that actually being addressed in this space?
But you know what, if I was the advocate for your friend, the person that you've referred to, the steps I would take would be to probably pick up the phone to Russ and have a chat about it. Also, or a First Nations person who I could get some guidance from. But if I wanted to do some formal correspondence and with that consultation, I would probably extract parts of that report in a letter to correctives. That's what I'm thinking. What would I do? How do I use these resources on those very issues about social, emotional wellbeing, connection to family? Yeah.
Thank you. No, that's good advice.
Yeah. Rebecca, I'm just keeping an eye on the time. I've just acknowledged that we've got a hand up and we've got a question in the chat box to answer before we finish as well. And Mark's also here. Hello.
Speaking of Kay Griff in the chat box.
Yes, we've got a outstanding question from. We'll address that first. You're a bit quiet there, Mark. Yeah.
That's because that's not there.
So there is a question from Kay Griff. Kay Griff, yep. Would you like to actually take your pop your mic on and ask it yourself if you like, or I can see that you're in the space. Would you like to ask your own question there?
Yeah, hi everybody. My question was it's been answered. Rebecca's answered that for me. Thank you. It was just if the evidence that you rely upon in relation to the hardship is not available, how then do you go about proving the prior disadvantage in order to have that taken into consideration?
Well, do you know what? And hello to you. It's been a long time since I've seen you.
It has, Rebecca. How are you?
We used to be opponents, everyone. But always a pleasure. Look, what I would say to that is you can find that. You can find that evidence. For example, and I will try and be quick, everyone. I'm conscious of the time. But for example, the chapter 2, exposure to domestic violence, not only does it talk about impacts, it talks about the breadth of that experience. Now, an example of what I mean by that is that even if you are an infant and you are exposed to family violence, the evidence shows that has a profound impact upon your lifelong outcomes. So how, if you've got a client, do you get evidence of that if your client's the baby? Okay, what you do is you subpoena facts. Department of Justice for previous records that might indicate if a child has been taken into out-of-home care, for example. So that's some records that might be able to show that experience of disadvantage. Alternatively, you just talk to community members, you talk to family, you talk to the auntie who was around that knew that that was happening. So it can take a lot of work, but you've got to be an investigator, and you can find that evidence if you work hard enough and talk to enough
Rebecca.
organisations. Yeah.
Thank you.
Thanks for that.
Beck, did you still want to ask your question?
Yeah, I was just about to say, hand over to Beck there.
Good morning, everyone. My question was just more, this is amazing and well done, Rebecca and Russ, with the Bugmy bar book. My question was more, so I suppose I'm doing my PhD on police discretion at the moment, and using a cultural framework on doing appropriate police discretion with elders from an Aboriginal perspective. And I'm just looking at this and going, this is amazing. So my question is, how can this be used at the front end of police discretion and decision making, so it doesn't come up to court and sentencing? Because from a police officer,
Gosh, what a question. Can I just say some things that are pinging for me rather than going too deep for time?
Yeah.
My brain's just going. Anyway, lots of ideas that we're having already about things we want to develop, because we're just coming into a new funding period with hopefully another employee that can action some of this stuff. But I'm starting to think about things like, how can we build the resources, use what we have, but also build the resources for cultural competence and cultural awareness for police. That's one thing, okay? Another thing might be and we've wanted to do a chapter on institutional racism in policing, for example. So developing that chapter, no doubt, would inform your work. So there is a range of topics. And in fact, Beck, I'd love you to get in touch.
okay, cool.
Because again, it's a responsive project. It's not telling people what to do. It's listening and responding.
Yeah, awesome. I'll be in touch. Thank you.
I think we've answered most of the all the questions in the chat box. So I'm happy to hand back to Russell and Rebecca as to anything that they felt that they haven't covered off as yet.
Lisa, do we have till 11? Is that our timing?
You do. You do.
Russell, do you mind if I just talk a little bit about
Go for it, Beck.
Okay, I just want to make sure that I kind of start to cover some of the other ways in which the bar book can be used. And Mark and Lisa, let me know if you want me to go down a different track. But the resources can be used in bail as well, in lots of different ways. I'm just giving you an example. And part of the learning, I think, and discussions that we're having here is that you need to be creative about your own case and what it brings in terms of using these resources. But as you would know with bail, some of the key issues that the judicial officer has to consider is, firstly, is the person going to turn up to court? And secondly, are they going to reoffend? There's other considerations, but they're key ones that the court always deals with. Now, I'm just thinking about a client of mine who was in the Wallama court, and that is an Aboriginal sentencing court in the New South Wales District Court in Sydney. And when I applied for their bail, I was assisted by my instructing solicitor, and we managed to get him into a First Nations controlled rehabilitation centre. Okay, so our evidence was that of where he's going to go. But the report by Dr. Gray and Ms. Edwidge, of course, is a research review and expert opinion. They're both First Nation psychologists that talk about the likelihood of success of culturally safe and appropriate programs, and likelihood of reducing recidivism when people are engaged in cultural activities, culturally safe, therapy, and so on and so forth. So marrying those two things together makes for a very strong argument, coming back to the bail considerations, that they are unlikely to fail to attend court. That is, they'll show up because they're being cared for in a way that's culturally safe, that's likely to work for their issues. And secondly, they are unlikely to reoffend because they're in a culturally safe environment that's likely to assist with them with the issues that they're facing. So that's another example in a bail context. But one other thing that I will say, and I'll try and do this in 2 minutes, but I'd love to talk about it in 2 hours, is again this the strengths evidence and the example. We're building the resources, but I'm going to come back to Dr. Gray and Vanessa Edwards' report again. But this Wallimer client of mine, who probably brought me the best day of my professional career a few months ago when he graduated from that program, and I'm getting kind of thinking about it. But he at his sentence hearing, he was a poet and an activist and a very, very talented writer. So I was so privileged to be able to tender on his behalf some of his poetry and his art, and to be able to ask questions about what that art represented. Some of it he had done in jail and it had cultural significance to him. Okay, so this is an example again where you get the evidence and then you put the research on top, okay, to then strengthen that for the court to make particular findings. We had lots of other evidence of strengths about his family, his beautiful family and community and cultural connection. But just using the art as an example, Vanessa and Paul talk about the importance of art in terms of cultural significance and well-being. And I, in fact, had Dr. Robert Shields, who was a First Nations psychiatrist, come along and give evidence in conclave with another psychiatrist for him, who was saying, gave a whole background about the importance of art to culture. And all of that strength evidence put together had a very significant impact because he was on the borderline of jail or not. So that was the key question in the sentence hearing. Does he go into jail full time, or does he get what's called an ICO, an intensive corrections order? Now, to get an intensive corrections order, and I'm coming back to this because you've got to tie all of it's no good just to kind of tell the story. You've got to tie it back to the principles as to what you want to get in court, right? So with that question about jail or not, it's all about community safety, Section 66 of the Crime Sentencing Procedure Act. And what we were able to demonstrate, amongst other arguments, was that all of this strength goes towards his prospects of rehabilitation. If he remains in the community doing these things, these culturally appropriate things, the community is likely to be safer. As the alternative, lock him up where there is likely to be none of that. Okay, so that was a very persuasive argument in terms of using that strength evidence, both in terms of the research and his personal experience, to argue to keep him out, and he remains in the community. Okay, so it's powerful stuff, and I think using and educating oneself about what's on the Bugmy Bar Book and beyond, it's not be all and end all, makes for much better practice and much better outcomes for clients. Thank you.
Russell, we are very close to time, but I really would like to invite you to respond to that before we wrap up. And thank Rebecca. I'd like to thank Rebecca as well for that, because it just demonstrates that to me that the Bugmy Bar Book is very much an organic sort of thing. It's a very dynamic, and as you said, it's an evolving and it's a growing and changing collaborative exercise, which to me is very exciting. Russell?
Yeah, it's exactly. It's a living document, basically. I think that's the part that we need to understand here is that it's going to be something that is when you use the Bugmy Bar Book, that you take that Bugmy Bar Book and understand what it means, how you need to bring it all together. but also around how it's going to give you the substance that you need in what you're advocating. It is so important that you actually get that drawing that all together, particularly also understanding the cultural understanding of it, how it really means that the culture with what the Bugmy is saying and how you've got to present that in a way that the person listening to you, whether it be a magistrate, whether it be a tribunal member, that they understand what you mean and where you're coming from, and that the person that you're representing looks at you and goes, they get me, they understand me, they know what I mean. They know I'm not something that's just sort of, oh, just another client. They feel that they know you. Biggest issue comes from this, and I've always had it for years, is that once you become their friend, you're a friend for life. Because the thing is that they'll go, you know me, you know exactly where I'm coming from. And that's really, really so important in regards to the book. The Bugmy book is just such I think it's actually is the foundation of where we need to go in the future, and how we need to and use it in the legal profession.
Thank you so much to both of you. We are that much richer in the centre for having experts to come and to share their wisdom and their expertise, their skills and their knowledge with us. And I'm incredibly grateful to both Russell and Rebecca for spending the time with us this morning. Can I just invite everybody, there's some love coming through the chat box, and I just invite the students and faculty to express their gratitude for them coming and sharing their sunny Saturday morning with us online. And we look forward to hearing more about the Bugmy Bar book as it becomes, as we said, this organic, dynamic thing. Beck Lewis is going to be in contact with Rebecca McMahon moving forward, so that's exciting to hear as well. And for the rest of the students, you will probably hear from Rebecca McMahon and Russell Kavanagh in future subjects, because we never let them go. So thanks again, and we look forward to being in contact with you both.
Thanks, Lisa.
Thank you so much. Such a pleasure.
Yes,
Enjoy
thank you very much. You too. Thank you. Bye-bye.
Bye-bye. And that concludes our second guest speakers session. So I'm going to stop the recording there.